Hello and welcome. Thank you for joining me today for a discussion of no probate, how to get the right estate plan in place and avoid probate. My name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning. We serve clients in Washington State and in North Idaho. So if you are listening from a different state, I want to make sure that you're aware that what I'm talking about today might not apply in your state. So talk to an attorney in your state. No probate, how to get the right estate plan in place. In order to understand what is going to be the right estate plan for you and whether or not avoiding probate is the right plan for your estate, I think what would be helpful is to go through and talk about, well, what is probate? Let's demystify probate. Probate is such a misunderstood area of the law, and for good reason, in that when we hear of a probate, what we hear of, in the news or in the press is that some really bad situation, probate gone wrong, family dysfunction, all sorts of really horror stories about a probate. So not surprisingly, most people, when they hear probate, think, oh, that's a horrible idea. I never want my estate to go through probate. So we're going to talk about that and why sometimes probates are terrible. And we're going to also talk about how probate might be a really good idea. But to even get into that discussion, we need to discuss, well, what is a probate? We're also going to be talking about if your estate plan should be set up to avoid a probate. How do we set up your estate plan? And we'll be talking about, all right, well, perhaps your estate plan would be better served by a probate on your death of your estate. And we'll talk about that as well. So that my goal is that by the end of our talk today, you'll have a much better understanding of probate and of estate planning as well, and how those fit together. All right, let's go ahead and get started. What is probate? Probate is the legal process of settling the estate of a decedent. A decedent is the term for someone who has passed, someone who has died. Estate is everything that they own. So on their death, where do their assets go? Probate is a process to determine where things go. Practically speaking, what happens in a probate is the person who has been nominated in the will, or if there's no will, a person who has authority files pleadings with the court to initiate, to open the probate. This is why people sometimes get concerned, because they say, oh, the court is involved. That doesn't sound like good news. Well, it may or may not be. It depends on the situation. So think of probate as the process to settle someone's estate. If there is a will, the original will be filed with the court in the county where the person resided, and it will be filed together with a petition to open probate and to appoint the personal representative. That's also called the executor. Then when the court says, okay, I've looked at the will looks like a good will, the person's been nominated in the will to serve as the executor, the personal representative, then the court issues what is called letters testamentary. That's the legal authority for the personal representative to take control over the decedent's assets and manage them. By manage, what I mean is the personal representative gathers the assets, takes an inventory of them to say, hey, what is there? Then also will pay any legitimate creditors that are owed, and then ultimately distributes the assets to whomever is entitled to receive them. That is it in a nutshell. let me get into a little bit more detail, because with a probate, what often happens is that people don't understand all the steps involved in a probate. And I am not teaching a law class here, but I do want to give you a little bit more information about what is involved with a probate. In Spokane County, for example, a filing fee is paid to the court, the personal representative, and currently it's $240. The personal representative also submits an oath promising to do their job, and then the court grants the letters testamentary and an order opening the probate. Typically, this happens about a month or 2 months after somebody has passed away. There's nothing that says it has to happen in that time frame, but there is a rule that says that if anybody has the original will, they need to give it to the personal representative nominated or file it with the court within 40 days of someone's death. So that's why we say it's about a month or two after a death happens. Now, not to get too far into the weeds, but I do want to let you know that if there is no will, there still will be a probate. People often confuse they say, if I have a will, that means there's not going to be a probate. And no, that's not the case. A will means there likely will be a probate if the estate plan is set up to have a probate. But if somebody did no estate planning at all, somebody still has to settle their affairs. And how's that going to happen? It's going to happen through a probate where there is no will, and that's called an intestacy probate, meaning there was no will. And then if there's no will, then who's going to serve as the personal representative? Well, it depends on the person's family situation, but if there's a surviving spouse, they would be able to serve. If there's no surviving spouse, then the adult children of the family have a right to serve. And so the state does have a hierarchy of who has authority to serve as a personal representative. And then in that case, if there's no will, it's not letters testamentary that are issued, it's letters of administration. But it still gives authority to somebody to manage the person's affairs. Once the probate has been opened and the court has opened it and issued the order and the letters, then what happens? Well, again, this is why I say, if you are in a state different than Washington or Idaho, talk to a lawyer in your state, because in Washington and Idaho, our probate laws are friendly, I would call them. Yes, there's still laws. You still have to do this and do that and do that, but the court is not involved if it is what we call a solvent estate. Solvent means that the estate has more assets in it than debts. If there are more debts, it's an insolvent estate, and then that leads to court intervention. That means the court's involved with everything. Typically, though, we are working with a solvent estate, meaning there's more assets than debts, and so the court is involved with virtually nothing in a probate that is not an intervention probate, which makes it much easier because the court doesn't have to give a stamp of approval or give authority. They already gave authority through the letters that were issued. So we'll talk about solvent estates. If you have an insolvent estate, yes, that's much more complicated. The court's going to be involved. So solvent estates. What do you do next? The court has issued you letters. You're serving as the personal representative. And maybe you have a lawyer, maybe you don't. We do actually have a guide. It's called a do-it-yourself probate guide. We're happy to provide it to you to give you some guidance. But what we typically find is that people do require some legal help to properly get through a probate and not make mistakes. All right, so you've been appointed the personal representative. Within 20 days of your appointment, you must provide notice to anyone who is a beneficiary who's named in the will, and anyone who is considered an heir at law. An heir at law would be those people who would be entitled to receive if there weren't a will, and so this gets a little confusing, you have to give notice of the probate to people who are not receiving anything under the will? Yes, you do. So let me give you a simple example. Your parent died and they were single at the time of their death. Their will says everything goes to two of the children. The third one is disinherited, and you are named the personal representative. You and your one sibling share the estate equally. You still have to give notice of the probate to the disinherited sibling because they are called an heir at law. That gives them the right to contest what's going on. They might say, oh no, my sibling procured this will through undue influence. It wasn't dad's intention to disinherit me, this or that. It's one of the reasons it's really important to have a lawyer draw up your will, because if you do that, then it gives more safeguards to an argument of undue influence. Doesn't, preclude it, but does make things a bit easier typically. So you give notice to the beneficiaries and the heirs at law. You give notice to the state of Washington, to the Office of Financial Recovery, Department of Revenue, to make sure that they're aware. Perhaps there's a lien against the estate for long-term care that was provided on behalf of the decedent, but that's one of the notice requirements. So giving notice is really important. And that's something that if you don't give notice because you're not working with an attorney can cause problems in dividing up the estate later. So you've given proper notice, you gather up all the estate assets, you redirect the decedent's mail to your address. So you go through and understand what bills are coming in, what assets there may be that you were unaware of. You figure out what all the assets are. Typically, especially when you're working with a lawyer, you're going to publish a notice to creditors in the legal newspaper in the county where they resided or where they owned real property. And that really shortens the period of time that a creditor can say, oh, the estate owed me money. If you give notice to creditors instead of a 2-year period for a creditor to come back and say, I was owed money, it shortens it to 4 months. And so it's a much shorter period of time. During this period of time, you also do need to give notice to what are called reasonably ascertainable creditors. What is that? That's somebody who you should know has a claim against the estate. Give them actual notice. It's not good enough to just publish in the newspaper and cut off their claim. You give actual notice to that creditor and, put them to the test. Do they really have a claim or not? If they do, they have to follow the legal procedure to file their claim with the court. They have to do it correctly or they won't collect on their claim. So that's what you're doing. You're gathering up all the assets and figuring out who are creditors and who needs to be paid. Never forget the IRS. The IRS might be owed money. Maybe dad didn't file taxes for the last few years and should have. Make sure that that is taken care of because you don't want to divide the estate between you and your other sibling. Later come to find out the IRS, which is called a super creditor, is entitled to some of that money. Now, what are you going to do? How are you going to get it back? So make sure that all taxes are paid. Speaking of taxes, if I was just talking about income taxes, estate taxes in Washington state, if an estate is approximately 2.2 million or less, there's no estate taxes owed. In Idaho, they don't have a state estate tax, and they're just dealing with the federal level currently, which is 12.92 million. So typically, estate taxes aren't owed unless the estate is, above 2.2 million. All right. And I was mentioning paying taxes because that's paying what the estate owes. And then the next step in a probate is to distribute the estate assets. And you get a receipt from your other sibling, the one in my example who doesn't get anything. They don't get any money. They don't have to sign a receipt. And then you file what's called a declaration of completion, and then you're done. That's all there is to it. The court wasn't involved. You filed a pleading to close out the probate, but you didn't need any permission or get any order approving it typically, anything like that. So that's usually how a probate will go in the state of Washington. In Idaho, it can be even simpler than what I've described. So that's all there is to a probate. So why does probate have such a bad name if that's all there is to it? Well, it depends again on the state. In California, as I understand it, the legal fees are going to be dependent on the size of the estate, a percentage. That is not how it's done in Washington or in Idaho. The legal fees are going to be dependent on how much work did the lawyer need to put in to assist the personal representative in doing their job and properly administering the estate. In some cases, it can be very small. And when I'm talking legal fees and I'm talking small, keep in mind legal fees are typically more expensive than, other fees that you pay, but you're making sure you get it done right. So the legal fees could be $2,000, $3,000, $5,000, even $10,000 or above, depending on how complicated the estate was. That's why sometimes people say, oh, I just want to do it myself. That's why we have a do-it-yourself ebook that we'll provide to you. Just be aware that if you do it yourself and you don't do it right, you have assumed all of the liability for missteps, which means rather than you paying the attorney to help you, to protect you, to do your job right, you now are at risk of paying any creditor's claims or taxes or paying back anything, that wasn't done correctly. That's one of the reasons that we do recommend in a probate that you do get legal assistance. That's what a probate is. So why are probates have such a bad name? Because when we hear of a probate, we hear of the one that is totally gone wrong, that the beneficiaries are lawyered up each and fighting each other, that the will may have had some undue influence and it was maybe drafted by the decedent in the final stages of their life and a lawyer wasn't involved. Or very commonly, the person didn't have a will. So things are very confusing when there's not a will. And there are laws to say where do the assets go when there's not a will, but I can tell you it's far more complicated because you have to decide, well, what kind of asset was it? Community property, separate property, who gets what. Oftentimes, keep this in mind when you're hearing a story about a really difficult probate. I would say more often than not, you are dealing with no will or a huge estate, maybe where there wasn't a will, or very bad estate planning and dynamics. But for most people, a probate is not going to be that nightmare scenario. One of the things that I will say is that sometimes people say, well, I hear that in a probate, everybody's going to find out everything about me, my life, my family, my money. No, what's going to happen is the will be filed with a court. And yes, the will says who you are, whether you're married or single, and whether or not you have children. So they'll know your family. The will shouldn't say anything about how big your estate is. In the probate, I said we gather up the assets and we do an inventory, but we don't file anything with the court about the size of the estate or the inventory unless we have to. Why would we have to? Because a beneficiary demands it, or demands an accounting, or a creditor demands that the inventory be filed because we rejected their creditor claim. So there are some situations, very uncommon, at least in our practice, where an inventory is ever filed with the court. Why I'm explaining that is that means, looking at the probate matter filed at the courthouse doesn't say anything about what the assets are. Typically, what we put in our pleadings to start the probate is that assets exceed debts by $10,000 to show the court it's solvent. So that is what a probate is. I guess I went into a little bit more detail, so not in a nutshell. That's a pretty accurate description of a probate. So probate in of itself is not a horrible thing. It's not a good thing. What that kind of begs the question. Remember, part of what we're talking about today is with the right estate plan. So really the key question is not, is a probate a good thing or a bad thing? The real question is, what's the right estate plan for you? So let's talk about what is the right estate plan. And to help understand that, we are going to talk about ways to avoid probate and why you might want to avoid probate. Well, obviously, the reason you want to avoid probate is you don't want to go through that whole process that I just described. So how do you avoid a probate? One of the most common ways to avoid probate is through what is called a revocable living trust. And many financial planners throughout our country say everybody must have a revocable living trust. And I'll have to say that really they shouldn't be giving legal advice. How can they say everybody needs one? Because how do they know what the laws are in, the state where you live? Again, I'm speaking about particularly Washington state right now. But in Washington state, since our probates are relatively easy, straightforward, non-intervention, there's not a big push to have revocable living trusts. And there's some good reasons not to that I'll get into. But that's not to say that a revocable living trust isn't a really good estate plan. It depends on your circumstances. The other estate planning tool, the primary estate planning tool, is a will for passing assets on your death. So we're going to be talking about a trust, a revocable living trust, versus a will. And we're going to start with revocable living trust. So what is a revocable living trust? It is a legal document that you sign, and since you're signing it, and it has to do with your assets or your assets and your spouses, you'll be the grantor of it when you're creating it. It's also called the trustor. You likely will be the trustee, and maybe your spouse will be the trustee too. What that means is trustee is the person who is in charge of managing the trust. And you will be the beneficiary, and your spouse probably too, of the trust. So you get all the benefits of all the assets in the trust. And because it's a revocable living trust, it's a see-through entity for tax purposes, which means you don't need to go out and get a new tax ID number. You use your own Social Security number. So you have this legal instrument. It is intended to manage all your assets. And the primary purpose of this is that upon your death, the assets go where you say they go without you needing your estate to go through the probate. So in order for your revocable living trust estate plan to work, you need to put all your assets into the trust. By that, I mean you need to retitle your bank accounts, your investment accounts. You need to do a deed on your house to put the house in the trust. As you go forward, there's some maintenance involved with the trust. It's not a one and done thing. And that's where I think people really run into trouble, is they don't realize that, hey, there's a new CD offering at 5% interest. So I'm going to go take some money and open it up at this new financial institution. I'm going to put the CD in my own name. That's problematic because you need to put that CD in the name of the trust, in your name as trustee of the trust. So where people run into troubles with the trust is because they don't understand it, they don't maintenance it correctly, and on their death, all the assets aren't titled in the name of the trust. And if all the assets are not titled in the name of the trust that have to be, then what happens is these assets outside of the trust need to be captured and brought back into the trust. Well, how do you do that? That is done through what is called a pour-over will. When you sign your new revocable living trust, when you created it, you also signed a will. And that will said that any assets that aren't in my trust will be captured by probate and put into the trust. So not only do you have a trust administration on your death, but because you don't have all the assets in your trust, there's also a probate on your death. That means what you intended to avoid, a probate, by having a trust is not avoided. There are a lot of stories, I'm sure a lot of attorneys can, and you probably have heard of, trusts that didn't work correctly. One of the ones that really stuck with me was an attorney had drafted for this single person with a very modest estate, a revocable living trust. And the attorney didn't, whatever happened, the house did not get put into the trust. So remember what I said, if the asset isn't in the trust, there has to be a probate. So this single man had no kids, and all he wanted was, he had loads of nieces and nephews, and he just wanted his favorite nephew to get his bank account and to get his house. And that's what the trust said, but the trust wasn't funded. So instead of the trust working properly, there needed to be a probate. And recall what I said with a probate. When you do a probate, you have to give notice to all the heirs at law. In this case, there was something like 18 heirs at law. So there was a lot of work that was required because the trust wasn't properly set up and funded. The nephew ultimately got what he was entitled to, but there were a lot of unnecessary legal fees and work because the trust wasn't set up correctly. And that is really not that uncommon. And there were simpler ways to avoid probate that I will talk about in a moment. But the point of it with a revocable living trust is it can work to avoid probate if you understand your trust, if you perhaps meet with your attorney every couple years or 5 years and say, hey, is this set up right? Am I doing this right? Another issue that we often see with all estates, probate estates, trust estates, is that not all assets are going to be directed or captured by a trust or a will. So think about your 401k or your IRA. It has what's called a beneficiary designation on it. And you want to make sure that the beneficiary designation is correct, that it pays to whomever you want to receive it. You don't want it to be without any direction because it could pay to your estate. And if it pays to your estate versus paying to a person, then there's some bad tax consequences that come from that. So oftentimes people just don't realize that one of their biggest assets is not taken care of by their revocable living trust or their will, that they have to actually make sure that the beneficiary designation on that asset is correct. So how do you know that? If you're doing your own estate plan, you likely don't. Your lawyer needs to be talking with you about all these, what we call non-probate assets, IRAs, life insurance policies, 401ks, 403bs, that sort of thing. So a revocable living trust can be a really good idea to avoid probate, especially if you have real property in more than one state. If a revocable living trust is such a good idea, then why would anybody ever recommend a will? Remember, I said that a will means there likely will be a probate, the process I described earlier. Why would you ever want to go the more formal route than just having the successor trustee carry out the terms of your revocable living trust? Well, one of the reasons for that is the successor trustee after your death of a revocable living trust, they don't get any legal help because they don't know that they have to, or they don't want to pay the legal fees. And so guess what? They don't carry out the terms of your trust. Nothing happens. Or maybe something happens, but it's not exactly what should have happened. And nobody else understands how the trust is going. Maybe they're, the situation is 2 of the 3 kids should inherit, but there's nothing done. Maybe just the successor trustee takes and manages it. Maybe they don't. What I'm saying is that, and even if it's not ill intent, people just don't know what they don't know, so they don't do things correctly. Let me explain a scenario where we often see a revocable living trust not being correctly administered after a death, and that has to do with a couple. So with us, spouses, especially in Washington and Idaho, it's community property. And on one person's death, they don't know and they don't do anything. And it's just like the revocable living trust was before the person died. But typically in a revocable living trust, when a decedent dies, their share, their half of the estate, is supposed to go into an irrevocable trust with a new tax ID number. And that irrevocable trust can be for the benefit of the surviving spouse, and the surviving spouse can manage it. But oftentimes the surviving spouse is not to redirect those assets elsewhere, like to a new spouse. Instead, the assets in that irrevocable trust are supposed to go, for example, to the kids of that marriage, the decedent and the surviving spouse's marriage. But because the trust was never set up, there is the possibility of a disinheritance of those kids, because the spouse just does a new estate plan with the new spouse and everything goes to the new spouse or the new spouse's family. You might have heard of such a situation because it happens. Another reason beyond disinheritance that a revocable living trust might not be a good idea is maybe it's a taxable estate. Maybe this couple had $4 million. So their revocable living trust is set up that on the first death, that this irrevocable trust is set up. And it's not just to avoid disinheritance of the kids, but it's to capture the credit exclusion amount of the first spouse to die. So if we have a $4 million estate, $2 million, half the decedent's share, is supposed to go into this trust. That means that when the surviving spouse dies, their estate doesn't pay taxes on that $2 million, because that $2 million was exempt because it went into this tax exempt trust. Instead, the surviving spouse, their $2 million passes under Washington's laws tax-free because it's only their $2 million. But what happens again is that the surviving spouse didn't set up the trust properly. Instead, rather than the $2 million passing of the deceased spouse going tax-free and the $2 million of the surviving going tax-free, instead what happened is surviving spouse has $4 million. What does that mean? That means that's above Washington's credit exclusion amount for estate taxes. And there is going to be an estate tax of at least $200,000 plus on that because they didn't do it right. So they paid $200,000 in unnecessary taxes because they didn't understand their trust. They didn't talk to a lawyer who, for a very small amount of legal advice and fees, would have made sure that they avoided a $200,000 estate tax. That's one of the reasons that revocable living trusts, while they sound like a really good idea, in practice don't work well. And as an estate planning and elder law attorney, I want to make sure that you and my clients who I serve understand what are the risks of going what looks like an easier route versus doing things through probate, because through probate, you're likely going to have a lawyer and you're not going to have that estate tax liability because the will have a trust set up properly because a lawyer will help in that process. So those are some reasons that you want to really give some thought to what you think might be an easy, just do a revocable living trust. You never need to see the lawyer again. That's really a bad idea. If you have a revocable living trust, make sure you see your lawyer again. A will often is set up so that there will be a probate. Why? Well, to avoid those problems that I just talked about with unintentional disinheritance, not properly funding a tax trust, not properly funding other trusts. Beyond that, and this is really just an important part of Washington's laws that I want to make sure that if you are a Washington resident and if you are a married couple or in a partnership, a domestic registered partnership, that you understand that Washington will not honor revocable living trusts to set up an asset protection trust against long-term care costs for your surviving spouse. So I know that was a lot of words, so let me explain it again. So in Washington state, let's say you are a couple, you're married, and you are concerned that you want to make sure that you don't leave your spouse in a situation where your spouse will have no money when you're gone. And this is the key, you're concerned about long-term care costs. And frankly, long-term care costs can be huge. I mean, $10,000, $12,000, $16,000 a month. And you are concerned that when you're gone, your spouse will need long-term care. Perhaps your spouse has a diagnosis already of Alzheimer's or Parkinson's. There's all sorts of diagnoses that come, particularly as people age. And you're very worried all your money will be spent on long-term care costs. And that's a very common concern, very common. So let's take a situation where a couple has $1 million or $2 million. It doesn't matter. What I'm talking about is, well, it does matter. If you've got tens of millions of dollars, you're not concerned about running out of money. You're concerned about taxes. But if you are the majority of people who don't have a big taxable estate, you've got $1 million or a couple of million or whatever it is, you want to make sure you leave a nest egg for your spouse when you're gone. In Washington state, how we accomplish that is through a will that contains an asset protection supplemental needs trust. So for ease of math, I'm going to take a husband and wife and they've got $2 million. Let's say they have a very nice house worth $1 million and they've got $1 million in investment accounts. And one or both of them is frail or has a cognitive diagnosis. So let's say the husband is frail, the wife has Alzheimer's, husband dies first. His half of this $2 million estate, or $1 million, because a half of 2 is 1 million, will go through his will through the probate process into an asset protection trust his will creates through the probate process for the benefit of his wife, who has Alzheimer's. So what we would likely do in that scenario is we would take the $1 million of investments and put it into the trust for the surviving spouse. Then the surviving spouse has cognitive issues. She has Alzheimer's. She can't live alone anymore. That $1 million that is in this trust is not going to count against her for Medicaid eligibility. So there will be a trustee of this trust, obviously not the surviving spouse. And if the circumstances and the care were right, that trustee could apply for Medicaid right now for that surviving spouse. The $1 million in the trust does not count against Medicaid eligibility. The $1 million house does not interfere with Medicaid eligibility. So this surviving spouse could be on Medicaid immediately right away. That is the benefit of having a will with this asset protection supplemental needs trust. You cannot get that result through having a revocable living trust in Washington. Only through a will, through a probate, can we accomplish that $1 million protection. From a practical point of view, it's unlikely that the surviving spouse is going to go right away on Medicaid, because if she's been living at home with her spouse who has now died, she's likely going to go to a memory care facility with a 2 or 3 year private pay. So it's likely that that money in the trust is going to be used to privately pay for that period of time until the facility will accept Medicaid. So it's not the Medicaid program that won't put her on Medicaid. It is the fact that, practically speaking, memory care facilities have private pay periods that first must be satisfied before they will accept Medicaid. That nonetheless, I want to make sure that it's clear that Medicaid eligibility could happen right away. She had to, for example, go to a skilled nursing facility. They typically don't have private pay, and Medicaid would be accepted by the facility. And then the money in the trust is there to help out in any way it can. And then on the surviving spouse's death, that money gets distributed according to the terms of the will of the first spouse to die. That is a really good reason to have an estate plan that's based on a will that goes through the probate process. So when you're looking at what's the right estate plan for you, I don't know what it is. It's really important that you meet with an attorney that will go through what your situation is, your family, your health, your assets, your concerns, any worries about long-term care, or maybe you have long-term care insurance that will cover you for life or for 4 or 5 years, such that you're less concerned about depleting assets. That, everybody's situation is different. So meeting with an attorney is going to help you decide what is the right estate plan for you. A couple of other things, and I know we've got about 15 more minutes, and I want to make sure that I answer any questions, but I went through kind of the big reasons that you might want a trust, revocable living trust, or you might want a will. There are ways to avoid probate that don't involve a revocable living trust. For example, if you recall back to the gentleman who wanted everything to go to his nephew, and the attorney set up a revocable living trust and didn't fund it, and so he had to go through probate. There would have been a much easier way to set up that gentleman's estate. It would have been to prepare a transfer on death deed on the house and a pay on death designation on the bank account. Had that been done, then on this gentleman's death, the nephew would have taken the death certificate to the bank. The bank would have put the money into that nephew's name. He would have taken the death certificate and the real estate excise tax affidavit down to the county. County already has that transfer on death deed filed. County would have moved title over to the nephew's name. There would have been no trust administration, no probate, no notice to anybody. It's fairly automatic. That would have been the smart way to set up that gentleman's estate. We frequently do that in the simpler estates. Do keep in mind, though, that we will always have a backup for a will in case there was something that maybe this gentleman went out and got a new bank account and didn't do a pay on death. We will still have a will that says that it goes to that nephew. But if it's done correctly, then a probate will be avoided in a much simpler way without having a revocable living trust administration or a probate. All right, let me check the questions and answers. One of the questions is about trusts. And whenever you hear the term trust, ask more questions. So I was trying to be clear when I was talking about a revocable living trust, and I guess I probably wasn't clear enough. That's the kind of a trust that you could actually create yourself and you can revoke yourself during your lifetime. So that's why they're very popular, because you don't make it irrevocable, you don't have a tax number, anything like that. Trusts a revocable living trust or a will that creates trust can create all sorts of trusts. Both a revocable living trust and a will often set up for those people that have taxable estates, something that's called a credit shelter trust. And I tried to explain that oftentimes with revocable living trusts, those don't get funded. More commonly, with a will and a probate, they will get funded. Recall that was the trust. I think the example was the couple with the $4 million, that the decedent's $2 million goes into a credit shelter trust, which can be set up through a revocable living trust or through a will and a probate. And it's to capture the decedent's $2 million estate tax credit shelter amount. And this is called a credit shelter or a bypass trust. These all mean the same things. There's other kinds of trusts. The will with an asset protection trust protects that money against long-term care costs. You can also set up a special needs trust for any family member who might be on government benefits. And you can set that up through a revocable living trust or through a will. And then for many people, their pets are very near and dear to their heart. and they'll actually set up a pet trust. And you can set that up through a revocable living trust or through your will. And typically you name a caregiver, a trustee, and you fund that with a certain amount of money for any animals that you have that are alive at the time of your death. So trusts can be really useful tools for setting up the estate plan that you want to see and to manage your money and for those that you love. Here's a question. If a couple in Washington have an estate at $6 million and the revocable living trust is established, now remember, the revocable trust is established when you sign that trust. The pour-over will should have nothing to do with the revocable living trust. Why? Because the trust is set up correctly and all the assets are in the trust. But regardless, when the first person dies, then what are we going to be doing with, it's not 2 million, it's 3 million. You take the 6, divide it, 3 million. You're going to put into this credit shelter trust the Washington exclusion amount of the 2.193 million. Then typically there's another trust in the middle to take over the difference between the two to get to 3 million. And then the surviving spouse has their own 3 million that remains. So is that confusing? Absolutely. That's one of the reasons if you've got a $6 million estate, talk to the attorney. And what does your estate consist of? Does it consist of real property? Are there other options for avoiding Washington's estate tax? Out-of-state options, LLCs, all sorts of things might exist, or just inter vivos or lifetime gifting once the first spouse died, because then all the assets got to step up in an adjustment and tax basis. So it's a really good time to give away assets. In Washington state, we do not have a gift tax, which means you can give away assets with no tax imposed, at least on the giving away. You don't want to give away assets that have capital gains, which is why you want to be talking to your lawyer at that time. So that is, I'm sorry, perhaps a convoluted answer to the question, but whenever you are talking about taxable estate, don't rely on online forums or webinars or information. Really go sit down and talk with the lawyer. It takes some time to understand what your best options are for avoiding estate tax. In Idaho, it's easy, but in Washington, we've got that lower level estate tax. And then do keep in mind that in 2025, estate tax laws are set to change as well, and we don't know what will be happening. So definitely do keep things in mind about tax laws do change, not intended to change this year or next year, but in 2025, we don't know exactly what's going to happen. Any questions, feel free to reach out to us here at ELG Estate Planning. Our phone number is 509-468-0551. Of course, we have our website, elgwa.com. If you're in Washington or in North Idaho, meet with you and help guide you on your estate plan. Or if you are out of state, I hope you found this helpful. Do find an estate planning and elder law attorney in your state. Go to the National Academy of Elder Law Attorneys. That's NAELA.org to find a qualified lawyer in the state where you live. Thank you so much for your time. It was a pleasure talking to you today. Take care.